You can take over provided there is something that smells fishy, and that reason has to be recorded in writing before the state can enter into the picture. A person within the denomination has a problem with the practice. He can go to a civil court. Or the alternative in Hindu tradition is you go set up your own sampradaya. Section 9. And this was again reiterated in the Ram Janmabhoomi case as well, because that started through a suit only. I am conceding two things. State intervention is possible. And I'm also saying that state intervention is certainly amenable to judicial review. I'm making that statement. Can I read this out for the court's benefit? Just so that my position comes out here. Please, ma'am. It is, may I minutes? It is further submitted that neither in the exercise of 25(2) nor 26, the state can take over the institution of any religious institution citing maladministration. I'll explain where I'm coming from. 25(2)A speaks of regulate and restrict, not supersede. You can't take over the entire institution. I'm making the submission consciously in the context of HRC legislations, because in several states, the state is a squatter. It's a permanent tenant against whom there are no eviction proceedings possible, unfortunately. In this regard, I request the bench to kindly take a look at 31A of the Constitution just for a moment. Please take a look at 31A. Kindly see Article 31A, and this argument is captured at the bottom of para 33, but may I just read this for the court's benefit?
So there is no taking over as such under the state acts.
My lady, executive officers are...
Notified temple, it becomes a notified temple. Once it is a notified temple, the act will apply.
There is a slight difference. Kindly consider this. In Tamil Nadu HRC legislation, for that instance, I'm just giving an example. Specific provisions exist for constitution of trust for temples, without ever giving effect to the process of election for trusts. The state directly applies and appoints executive officer even when there are no instances of maladministration. This Honorable Supreme Court in 1965 Pandara Sanidhi as well as the Subramania Swamy judgment has clearly said, you can take over provided there is something that smells fishy, and that reason has to be recorded in writing before the state can enter into the picture. In the absence of doing so, the state starts exercising its marching powers, its police powers, and just enters the institution. So that is what para 33 covers. Can I request my lords to kindly come to page number 27, para 36 on jurisdiction of constitutional court and civil courts. I assure my lords this will be my final submission. I will not extend any further. Paras 36 and 37, allow me to read this out for the court's benefit because I think the language has been captured better here. My Lord Justice Varale has it. Para 36, page number 27.
Yes.
Since the powers under Articles 25(2) and 26 are vested in the state, and the state does not include judiciary in its judicial capacity, constitutional courts cannot entertain writ petitions which challenge the religious practices and beliefs of any religious institutions, whether codified or not. This is because codification of a pre-existing religious practice is merely an acknowledgement of a right under Articles 25 and 26 and is not a de novo legislation. If this position is not accepted, then the easiest way to circumvent the bar of judicial review on religious practices is by codifying such practices and thereby making them amenable to judicial review. In short, what cannot be done directly cannot be done indirectly. This also means that there is no basis for application of ERP test, since courts do not have the powers under Article 25 and 26 to preside over constitutionality of practices. In any case, as demonstrated, and kindly make a note of this, by Shirur Mutt, the discussion in the context of Article 25(2)A was not in respect of essential religious practice, but was in the context of essentially religious practice. There is a distinction between an essential religious practice and essentially religious practice. And essentially religious practice strikes a distinction between secular and religious. Essential religious practice is distilling what is religion. Therefore, that entire test has been misunderstood. Please see further the reason why constitutional courts have not been listed. I'll leave this minutes. Then my lords may come to.
That is in the juxtaposition of a secular activity.
I'm so grateful because the HRC legislation was the subject of discussion there of 1951. So the question was, what is secular activity associated with religious practice, as the learned SG had correctly.
How much was in debt? Question was, you required so much of money.
Please.
For that paryaya and all that.
Please.
When you are in debt.
Same Shirurman that I represent was before this honorable court. Please.
You see, it was in debt. And when you 1 lakh of rupees was the debt in those days was very.
Please.
High.
Princely sum in that sense.
Yes.
Please.
So when 1 lakh of rupee are in debt and you want to spend so much for paryaya.
Please.
whether the extent of expenditure was a question, and there was an inquiry and all that, and ultimately
Please.
they report, they said make a scheme.
Right.
That scheme was challenged by the
Challenged.
Matadipati there.
Saying it's exorbitant and they can't
Yes.
meet it. Please.
Can't, have a scheme because I'm spending so much.
Please, please. Can I request my lady to kindly come to page number 36, para 38? And this is on the question of civil courts, and these are questions that address the issues that specifically address the questions of Justice Bakshi and Justice Arvind Kumar.
25, 26.
Please, I'll just answer this one question.
Apart from
Constitutional-
something of interest there also,
Please,
there was one practicing advocate.
please.
He wanted to take control of the mutt because the Matadipati was a minor and then he was very young.
Please, please.
And he, through his friend, got a power of attorney and all that.
Right.
He started misusing that power of attorney.
Please.
There was a suit. Power of attorney was terminated by the Matadipati. There was a suit. And when that suit was there, all this happened because the advocate there managed all that.
Right.
Sorry to say that. And then matter landed up here and now we are in 7th judge, 9th judge.
Please,
That is the genesis of the dispute there.
please. Kindly
No
come,
essential religious practice.
kindly come to para 38 at the bottom of page number 36. Constitutional courts, however, can look into challenges to state action under Articles 25 and 26 when infraction of rights under 25 and 26 by state is claimed by the agreed parties. Please underscore the words who are bona fide beneficiaries of such rights. Even in such instances,
Limited jurisdiction. You understand? Can come to 37, 39. Civil court, you are rightly saying that. Civil court.
on 37.
I think everyone has argued that civil court.
So to answer the question, that if a person within the denomination has a problem with the practice, he can go to a civil court. Or the alternative in Hindu tradition is you go set up your own sampradaya. Almost every person, it's not as,
Question of, we understand, your question of religious practice comes, then civil court
I'm so grateful.
can determine.
Yes.
When the question of constitutionality of a state action comes, then a writ court can examine.
I'm so grateful. I couldn't have put it in better words. Milords, I have nothing more to submit. As far as page number 37 is concerned, I have given the Marthoma judgment as the example where the court has held that Articles 25 and 26 are rights of civil nature that can be exercised through the medium of Section 9. And this was again reiterated in the Ram Janmabhoomi case as well because that started through a suit only. And this was the basis of it. Milords, can I just take just 10 seconds to see if I've missed out something? I'm so grateful. Just continue.
You see the background of the dispute.
Very bound to be like.
One submission on the question of constitutional morality. A lot has been said. Grote, Ambedkar have been cited. I won't get into that. In my humble submission, the journey from 2018 September 28th till date is the journey of misplaced application of constitutional morality, which is, as opposed to applying the is position in terms of what the law says, when we go down the path of applying the ought position in terms of what the law must say, then we are entering the realm of policy. I'm grateful, deeply obliged, and I'm grateful to Mr. Subramanian.
Yes, Mr. Gopal.